have some material here that I thought I'd bring, and you might find interesting to review in your free time, or if you can't fall asleep at night. I find sometimes things that I write help people do that. And this is a brief that we filed in the Court of Appeals in the Castle versus Chopin case. And this case is presently on application to the Supreme Court of Michigan. And we're filing our briefs in that case in about a week or two, so I ought to get started on it. And so I thought now I'd just kind of talk through some of the ideas, and maybe I'd come up with some concepts to present to the Supreme Court on this issue. And this case is interesting because it encapsulates just about every element of the shareholder oppression case that I've seen, or that we see litigated at the trial court level. You know, abusive capital calls, firing the minority employee, stripping him of his shares when he can't pay the capital calls, interested transactions, which is a huge issue where there's related party businesses who are engaging in transactions with each other. And the Court of Appeals, there's some things to agree with the Court of Appeals and some things to disagree with the Court of Appeals in this opinion. And I also know that there's a conflict in this decision that may ultimately be what persuades the Michigan Supreme Court to take this case. And I know Dave Hansma is going to talk about some of the issues in the Castle case from the defense perspective, as is Brian Sachs. And I brought a couple of other documents that I thought you might find interesting from this litigation. And maybe if we could just pass them around. And one is the opinion from the case. One is a response brief. A response to a motion for reconsideration that we filed, which kind of sets the stage for some of the issues that we're going to see come into focus, either through the application in the business courts of this decision, which is unpublished, or the Supreme Court's going to take it up. And I got a hunch they will, because there's a couple of interesting issues here, and I think there's a perception from the bench and from the bar that these cases are on the rise, and sometimes there's sometimes the statute can be abused on the plaintiff's side, and sometimes the statute and the older concepts of fiduciary duty seem to be asserted a little overly aggressive on the defense side. And I do know that there's a committee that's being convened at the present time that's going to discuss recommendations to amend the statute in certain ways. So maybe next year we'll be talking about a new statute or a new precedent on this issue. So just briefly before I turn the podium over to Brian to talk about the prosecution, the plaintiff's side work on the minority oppression cases, just a quick observation that we've seen two Supreme Court decisions on these statutes in 3 or 4 years maybe. So it's clearly on the radar screen of the judiciary. And it's interesting because it's a confusing statute, and that's why we're seeing some of these things being resolved right now. I mean, if you go way back to when it was first enacted and being applied, and I forget the year, but there was a terrible decision called Box v. Maroon. It had two egregious errors in it. One was actually that the statute didn't create a direct cause of action, which is patently absurd because the statute was created to supplant the derivative action. So what else would it be for other than to create a direct cause of action? But corporate litigation at that time was really in the mindset of this derivative concept, stepping into the shoes of the company and making the demand. That's for publicly held corporations. When you're dealing with closed corporations, you have things like family businesses, friends, startups, and that kind of thing. And there needs to be special treatment that's applied in these contexts. And you'll hear Brian Reeder talk about some of the avoidance measures that apply in this context. And the avoidance is really, and the message that the statute sends, in my view, is that avoidance is good contracts. If you have good contracts with good exit strategies, and you can define, actually in some very basic ways that aren't that complicated, how it is that people will separate the the statute doesn't need to step in and fix things, because when the statute steps in and fixes things, it also breaks things and wrecks them, and ends up in the end to the company, or the demise of the company. I mean, it's sometimes impossible to allow a company to go forward when you're simultaneously seeking the remedy of a buyout. And the buyout is, it becomes oppressive in and of itself, and it actually can cause damage to the company. And so we really see a tension, and that's why I'm so happy that Judge Yates is going to share some of his observations here tonight, because the perspective from the judiciary is almost similar to a family court, which is, how do I tear asunder what two people put together at the beginning? And usually if it gets to the point where a judge is telling everybody how it's going to go down, that means something went wrong in the corporate governance. So we're going to hear from Dave and Brian, who are going to talk about the defense and the plaintiffs, the prosecution in these cases. Tom Frazee is going to talk about issues of how we value shares and possibly some other insights into the forensic evaluation of a company when parties are alleging that there's been misappropriations or embezzlement or interested transactions that might not be fair. And Brian Reeder will, as I mentioned, give us some corporate structuring observations. And finally, Judge Yates will answer questions and set the record straight. Tell us where we're going wrong on things. So thank you very much again. And Brian, if you want to come on up.
All right. Thanks everyone for being here tonight. So as Mark said, I'm going to talk to you a bit about the prosecution side, we'll call it, but no criminal law involved. Well, it could be, but not directly. So, but really bringing the action on the plaintiff side, and sometimes you find yourself defending a counterclaim, but in that respect, I'd be in Dave's camp. So, but for now, I'm going to talk just really about bringing the action. So, move forward here. So, it's prosecuting. Now, when someone walks in the door, and we have this happen in a variety of ways with the sort of the quintessential oppression action, you tend to see a few sort of typical markers. One is always, well, not always, but usually some kind of breach of a corporate governance document. You'll see some, whether it's a voting right that's been infringed upon, or maybe there's some kind of insurance to dividends that has been violated. So if there's a surplus, and they just stop issuing it. Another thing you'll see oftentimes is control. Just some way, somehow, whether someone's diverting the subject of the business to another area. We had a big case, Mark might have mentioned it, but Matagula was the first case to go to the Michigan Supreme Court on oppression. And that one very fundamentally involved simply redirecting the company to another specialty without sort of involving the minority. And in that case, there was a supermajority, which made it all the more easy to oppress, if you will. But at the same time, that case involved the flagrant disregard of voting rights. And so you always start with sort of those building blocks, and you also, there's a variety of them. You might have breaches of like I said, criminal law. You could have tax violations, things that jeopardize the company. You may have simply mistreatment, jeopardizing the staff, and a variety of issues. But the way I like to think of it, this is a lot, but I'll just generally say I try to divide it up and ask first, what are the theories of liability? Obviously you have a laundry list, and I'm going to list some of them here that I tend to always think about. Also, I say the shareholder inspection demand letter, but think of that as discovery. What do you need to get the ball rolling? And progressively, we've started to try to use experts early on in the case, and somebody like Tom is very useful for that, so that you can kind of define what are the documents I need to hit X, Y, and Z in my complaint, or even in an early mediation, which is really always should be the goal. So, and I call that the inspection demand letter, but can also be early document requests and the like. But the demand letter is unique in that it's statutory. You don't have to have a lawsuit pending to do it. What is shareholder oppression? We'll talk about that, the different types of liability. And again, Matagula expanded that. So did Frank v. Linkner, which is the second case to go to the Michigan Supreme Court in oppression. And then also Castle v. Shoham added to that. And that was the one Mark was talking about that's on its way to the Supreme Court of Michigan. Last one is remedies, which Tom's going to talk a little more about, the buyout evaluation. But there's a variety of remedies under the statute, but we tend to always look for at least two, which is usually the buyout and damages. Those are the key ones. And then derivative action, I list that there, but the thing to keep in mind there is really probably it's something to be avoided unless you really think you have to do it, because there's a variety of problems, one of which is that your damages then almost always have to be shared, sort of equal to the other interested parties. So I've been in a situation where I've had derivative claims and we've mediated, and half the discussion is talking about, well, how are you going to share the recovery that you get partly from the defendant with the defendant, who may own 75% of the company. So something to always think about. And then this last part kind of goes to what I was talking about earlier. I always think about it in sort of four components: the contracts that the parties may have. So often there's an employment agreement there. That's sort of the key one you see a lot. Corporate governance documents, that's your operating agreement, your bylaws, buy-sell, a variety of ancillary documents you can have attached to those. Statutes and common law. And with statutes, we'll talk about some, but the primary ones, of course, are your shareholder oppression action, which is 1489, 450, 1489, and the member oppression action, which is 450, 45, 15. And then offshoots of that, you have fiduciary duty statutes, you have safe harbor statutes, you have entire fairness statutes, and some of those we'll talk about in here. And then the common law, which used to be mostly based in fiduciary duty and some other areas of dissolution and where the sort of precursors to oppression lie. But progressively now we're dealing with actual case law based on the oppression statute, so which is, again, why we talk about things like Matagula and Frank v. Linkner and Castle, because they so there is a common law that is very strongly developed from the statute. So I'm going to just put these up and just very briefly gloss over them. But I talked about the first two. Those are your statutory actions. Partnership, kind of always think of as a definitely secondary to those, because it's often you may be proving it without even using a partnership agreement. That's where we find ourselves doing it the most. Just trying to imply a general partnership. Employment contracts, breach of fiduciary duty almost always is secondary to the oppression claim. It doesn't offer much more, or often offers less because the remedies are less defined. It's usually more of a damages claim that is literally the damages that flow are, that's what you recover. So it's a very vague standard. It does not entitle you to a buyout, for instance. Interested transactions, that doesn't have to be as a separate count, but it is, it does have a statutory foundation to it. But you can actually plead that within other counts if you need to. Fraud by omission, that's just a typical one you see where, you can imagine, but it's a lot of times withholding documents and dealing unfairly with a shareholder. Conversion, you have your common law, your statutory. There's an aiding and abetting tweak, or sort of special component a lot of us know about under the statute, which is why you find yourself pleading that a lot.
Well, and aiding and abetting was addressed in the Castle decision for the first time.
Right.
In this context.
So yeah, exactly. So actually, that's something I don't
To
get.
hold the individuals liable.
Right. So you have, exactly. So there, and that was an oppression action where that was a successful ancillary conversion, aiding and abetting set of claims, which is pretty rare. So give Mark credit for bringing that one to the forefront. So, because yeah, usually, I tend to counsel people against relying on those because you have the triple damages, gets people excited sometimes, but you got to be careful you're not dealing with, specified funds, as a general purse from which dividends can be issued, specified funds in which a conversion action can lie.
Do you feel it's advantageous to plead a derivative? Obviously, you have some direct accounts like fraud and maybe some other things, but do you find it moves a case forward, or kind of gets it stuck in the mud when you plead a derivative claim in conjunction with the oppression claim?
Yeah, no, I counsel strongly against that. Like I think I said at the outset there, that you have a problem with damages, you have a problem with possibly having to share a big pot of what you recover with the oppressor, him or herself, or their self. And also you got waiting requirements, they can convene a committee. There's a lot of hurdles that just don't tend to be worth it. But I'll talk a little bit about that after the fact. Unjust enrichment and quantum merit, just equitable remedies. So the demand letter, just real briefly, going to say that I said earlier, that's something you can use to get the ball rolling on documents. Just one or two interesting points on that. I know I've run into a situation where the defendant or whoever it is on the other side is saying, maybe corporate counsel is saying, I don't think your lawsuit is an interest of a shareholder. I've actually had like umpteen email exchanges on that issue alone. And what I find is there's a few things that are just clear in law. Trying to value your shares for whatever reason, you just want to know. Maybe you want to possibly try to get a third-party sale or whatever it is. I find that's something that is connected to a lawsuit, but it isn't the lawsuit. So, because truthfully, there is some argument that to just do it instead of filing suit or conducting ordinary discovery is not the best route. So you kind of have to have a sort of an independent, I think, hook, and that's one valuation. Another issue here is that you have to have an authorization, so your client would literally have to go and do the inspection unless they actually authorize you in writing to do it for them. So these are just some sample demand contents, but it's pretty much your fundamental financial building blocks that allow you to, again, not only assess value, but you always think of it as there's value and then there's what value is leaving the company. So when dealing with having Tom on my side say I'm going to try to get the things for value, but at the same time I'm going to try to get as many things in there that may just be ledgers and things about the in and out of cash flow that doesn't really get me my total value, but gets me what value is being lost. And that's in some ways more important than what the value is of the company in an oppression action. Sometimes it's where is the lost value. So, the company has to do a 5-day response period. This is very hard to comply with, and sometimes that can be used as a as a method to try to be get them to be responsible. The LLC has a analog statute to it. It's a little more flexible. There's not a proper purpose requirement, which is a broader standard, but it's the same type of demand statute. Defining oppression, it's a pretty broad standard, and as I'll talk about in a minute, you have what 1489 sets forth, but really it's three components we think about it as. You have illegal, which I'll actually go to the next page for this. Illegal, fraudulent, willfully unfair, and oppressive. And actually, before I get to that, I'll mention that under 1489 for shareholders, the defendant actually has to be a person in control or persons in control. So a director or those in control. So you don't actually have to be technically a member of or a shareholder of the entity or a director. You could just be part of a control block, which we see a lot. So theoretically, a corporate counsel or an accountant, or you don't see it a lot, but you got to sort of think of it in those broad terms. And under 4515, which is the LLC analog, I wrote down the language here. That is members or managers in control. So you actually there have to be a member or a manager in control. So more narrow under the member oppression analog. So illegal or fraudulent is really, the underlying sort of the history of that element comes from things like conversion, actual things that have criminal or penal code underpinnings to them. Willfully unfair and oppressive, though, is where you kind of get the broad, general, what we've come to think of as oppression, in that it's a pattern of willfully unfair and oppressive conduct. It's actually defined as a continuing course of conduct that interferes, you can see this, the definition, but substantial interference with the interests of the shareholder is key. And also termination of employment is a key addition to that statute about 10 years ago that definitely helps with when you have employment rights at issue as well. There's a laundry list of some of the examples of oppression. You see a list here. I'm just going to mention a couple interesting ones we've had in our cases, but one interesting one that comes to mind is a case where we actually had a buyout negotiation that didn't actually culminate or commence into the buyout itself, but in the progression of the buyout discussions, there was allegations that documents were withheld, important documents that showed different valuations. But there was a question on whether or not you had a duty to provide. But there, the trial court actually, and this is now on appeal, but held that even in dealing with, say, your minority shareholders in a sort of an adversarial negotiation, we're going to buy your shares back for X dollars amount, do I have an obligation to share with you all the sort of value documents I have if you haven't asked for them? And so there the trial court actually found yes, and that's one of the widest reaches that I've seen, and but I note it because it's actually more It's a broader reach than actually these examples we have historically. Historically, you have, you know, refusing to pay dividends when there's a surplus is a key one. Like I said, about breaching corporate governance agreements, and that became more apparent in Matagula. Also, diverting funds to other companies, starting other companies if they're not, you know, if it's not fair or ratified is another example. So Matagula, I know I've mentioned this a few times. So key in this case was, again, this is the first time that the statute ever found its way to the Michigan Supreme Court. And one is there's sort of a broad statement in that case about the breadth of rights to be protected. And so it's a key sentence there that I quote that says, it's including but not limited to the right to vote, inspect the books, and receive distributions. But even that including but not limited to is broader than what we saw in prior cases. I think it was Franchino, where there was discussions of a sort of very narrow set of rights, just what the statute says itself, so which is other places in the business code. And that's pretty narrow. So Matagula sort of opened the door to there being other places in which the rights can arise. And then that leads into the second and probably the most key holding to Matagula, which is that violations of a shareholder agreement here may constitute evidence of oppression. And so there, basically it was the stockholders agreement provided rights, which the court said become rights of the shareholder. So it's sort of for the lawyer to decide, in the absence of a stockholder agreement, would it still be in the statutory right? Maybe or may not. But if it is in that agreement, you can use that off the bat, a violation of that, and you can allege oppression based on it. So, and the last part of the Matagula holding is one that, you know, it sounds like it's a big deal, but in reality, there's a lot of ways to still make it work for the oppression lawyer, but it's that the trial's going to be by a judge and not by a jury. But in this case, actually, when it was remanded, what the Supreme Court really said, too, was you could still use the advisory findings of a jury. So you could still sort of make a lot of that fact-finding function be accomplished by a jury, and then decide what the Matagula judge actually had to do was just decide, do I agree with it? Do I find that it's within the realm of, you know, reason and all that? And that is what actually happened in Matagula on remand, was the court, you know, received findings of fact and conclusions of law and went with what the jury had done. So in Frank v. Linkner, which is the next time that this statute has went before the Supreme Court, you know, we saw three important holdings there. One is that the acts of fraudulent concealment will actually toll the statute of limitations in oppression action, and that had been definitely less than clear in prior case law. In some ways, I think the most interesting one is number two, which is that, so in Frank v. Linkner, there was a amendment of an operating agreement that created a waterfall provision. I'm going to sort of summarize it crudely, but it was something that hadn't actually resulted in a sale with calculable financial harm. At the time, the court said, looking back, you could have and should have brought suit. So the idea is, shareholder sitting there, he comes to you or she comes to you and says, I've got this new agreement they've sort of put on me, and I think it's oppressive if and when there's a sale, for instance. It's going to do this or that to me. They should sue. I mean, that's what's new here. Not only the sort of positive component for the oppression action is you can sue and you're not going to get kicked out of court, but you know, obviously the downside is if you don't, you got a statute of limitations that's ticking when that first non-financial harm occurs. So that's sort of three is sort of what I just said, but that's sort of the takeaway is that the clock starts ticking. So even without a calculable financial injury.
Speaking of a clock ticking,
yeah, are we there?
It's time to wind
All right. Well, you know, perfect, because I got one more thing. I got about 5 more things, but I'm not going to do them.
Hey, Judge, when a lawyer says he's got one more thing to say, what's that mean?
5 more things.
It's going to be a while.
5 more things I want to talk about. One I will, and it's because it's the one that my esteemed partner over here so eloquently took up to the Michigan Court of Appeals. But that's the Castle v. Shoham case. So key there, what's most interesting is that it took the sort of the key holding of Frank v. Linkner, which I know Mark briefed heavily about in Castle v. Shoham, and discussed there was the need for a calculable financial injury. It was recognized you didn't have to have it, and here it was the issuance of a capital call that was oppressive. You know, and it's, even though the plaintiff didn't even respond to it, but that issuance to try to make him do that and then punish him for it was the interference with the shareholder interest. She didn't actually have to exact the money out of him, or commence or have the act culminate in a financial injury. And the last part that I'll just mention.
So it was just the threat alone?
Yeah.
The threat alone was enough to cross the line?
The violation of the voting, the issuance of the capital call was not in accordance with the stockholder agreement. He did respond to it. That act in violation, that attempt to make somebody pay into the company when they weren't obligated under the documents, was enough to support the oppression claim. And then the last thing was just the finding of fairness under 450, 4409 is not conclusive as to whether the entire transaction was evidence. It could still amount to willfully unfair and oppressive conduct, so it's not conclusive. But Mark, if we have more time at the end, he can talk a little more about that, since that was our firm's case that he handled. So,
and what you didn't get to, we're going to email out the PowerPoint.
Yeah, you'll
slides,
see.
which you'll
But take 2 minutes and tell us what issues are on appeal before the Supreme Court on oppression.
you know, Cassie, you want to do that? And you know what? I'll just note too.
That sounds really interesting.
It is, yeah. And I want to talk a little bit about that. I'm just going to note what's still coming back, because it's an important thing you'll see in my notes when I send them, but is the remedies, because there's really, the buyout, that's what I didn't get to, but the buyout particularly, you have a lot of interesting issues, the forced buyback of shares, and this one thing I want to mention, because it's the oppression practitioner has to consider it, is which approach you're going to sort of guide or hope your expert goes through. And I tend to, we usually try to get them all, because you're going to sit there, so there's the asset approach, kind of like, book value, you got the income approach and a market approach. And those are the ones you kind of tend to see the variety of those in a good expert report, and then you can sit there and sometimes you have a corporate document that says it is an asset, it's an asset approach. So you're there, but you're also going to argue for fair value, because that's something that the statute says you can get, and that's usually without discounts. So
Not defined in Michigan.
no, it isn't. And yep, we've had cases where we're arguing up the whole, across the spectrum on what fair value is and what's the discount. Is it 15, 30? It's all sort of up for grabs. But we argue that it's usually, it is something that should be considered for sure, because there's sort of a punitive component to a forced buyback.
So I'm glad you brought that up on the fact that it's an open issue in Michigan, because the question of how you value shares in this scenario, there's a good argument to be made that it shouldn't be constricted, and that it should be a wide open question for the judge to exercise his discretion. But I actually think, since there's a policy, that in order to get to the question of the valuation, there has to first be a finding of some level of illegality, whether it's fraud, oppression, or illegal conduct, whatever that is going to ultimately one day be defined to mean. And so I think the stronger argument is that it should be a valuation method that's more advantageous to the side that's been oppressed. But it's not defined in the statute, and it should be. And I'm glad you brought it up, because it's another one of those issues like, why didn't we know there was standing? Why don't we know there's a jury trial? Why didn't we know whether it's a statute of limitations or repose? And also, the most prominent remedy in the statute, which is the buyout. Why hasn't the legislature told us about that? So now, and your question about what's going up into the Michigan Supreme Court.
What was decided in the Court of Appeals, and now what's the Supreme Court?
Okay, what was decided in the Court of Appeals was there's a significant holding there that the termination of the employee there wasn't shareholder oppression. And the grounds upon which the court determined that was that essentially, I think shareholder rights don't guarantee employment rights. And I agree with that in principle, because if there's going to be if you're faced with a statute that can be interpreted such that you're not guaranteed an employment right, there should be a contract on the front end. And I think that the Court of Appeals decision, it went against me. However, I don't necessarily disagree with it in terms of its logic. I think that it does make sense. In that case, it was wrong. He shouldn't have been terminated. It was part and parcel of a larger scheme. But a majority interest shouldn't necessarily be bound to forever employ someone. So I'm going to be filing a cross appeal in that case, and arguing for a broad interpretation of that part of the statute on employment. But the Court of Appeals ruled to the contrary, and so I'll be taking that issue to the Supreme Court. And the other, I think we'll probably hear some more on it, but one of the most, there's some fact issues that really aren't relevant in a broad sense in terms of what's going to the Supreme Court, but one of the issues that is, the operating agreement in the Castle case said that you can have a capital call by consent. And the problem was there was a defect in the consent. And so I think there's an argument to be made, and I'm going to rebut it, that deviations which don't cause damages don't necessarily trigger oppression. The problem is now we're faced with the Linkner application, but the Linkner application comes out of a statute of limitations analysis, and so there is a distinction to be made and a significant issue to be resolved, which I think those two issues are the ones that will pull the case up into the Supreme Court, although it remains to be seen. We never know.
So you're going to submit an application, it's not been granted?
There's an application been submitted. I'm responding to it, and then we'll be filing a cross application. I'm not too clear on the procedure of it, but we will be cross appealing on the one issue that went against our side, which was the employment discharge. So, and I'm sure Dave Hansma, talking about the defense, will have a few thoughts on it. Now, Dave, I did forget to set the timer for Brian, so he might have got a few more minutes than everyone else. I'm going to remember for you, so
It's still fair game.
If you've ever seen the great legal drama My Cousin Vinny, Joe Pesci gets up, he's doing his first opening statement to a jury, and he points to the prosecutor and says, I'm going to censor myself a little bit, he says, everything that guy said is bull crap. So that's basically my presentation, and I'm done, and I can sit down.
It was rough when they used to work together.
So Mark actually suggested I should bring a handout. So I brought something. I actually wrote an article that touches on the Castle case a little bit. It's been submitted to the Michigan Business Law Journal. I've been given some indication that it's going to be published. I don't know for sure if it's going to be accepted for publication, but it talks about the interaction of, well, I actually talked, Castle's an LLC case. I talked about the Business Corporation Act. It's just kind of more clear there lately. Castle has this interesting line where it's talking about, can something be found fair under 4515A, but still be unfair under the oppression statute? When I first read that, I said, no, that's stupid. How could that possibly be? And then as I actually was writing the article, I changed my mind and said, actually, it is possible in a very narrow set of circumstances. So anyways, this is just for your perusal if you want to read it. Hopefully you'll find it in the Business Law Journal this spring.
If not, we're a very select group.
You are very select. you and everyone on LinkedIn that Mark just posted today.
It's a secret society.
So the interesting thing about the oppression statutes, 1489, I think it's 29 years old now. I think it was 1989. And there's a pretty robust body of case law under the statutes, the vast majority of which is unpublished. It's either unpublished Michigan Court of Appeals decisions, or business court decisions, or federal decisions that aren't binding on anyone. There's only a handful of published Michigan decisions on the oppression statutes, which means that there's still a lot of room for argument as to what the statutes mean and how they're to be applied. And in particular, there's room for the defense side to push back against some of the unpublished decisions that have maybe gone a little far afield of what the oppression statute says. For example, the Bromley and the Berger cases, which were in Brian's list a couple of slides ago. So my first sort of piece of advice for defending oppression cases is really no substitute for knowing the law, and really knowing the law better than anyone else in the room. And what I mean by knowing the law isn't just knowing what the oppression statutes say and knowing the body of unpublished case law that kind of a lot of them contradict each other, but knowing Michigan corporate law generally and comprehensively and coherently, and knowing the gestalt of Michigan corporate law. And that really starts with knowing the acts that the oppression statutes are in. They're not standalone statutes. They're part of either the Michigan Business Corporation Act or the Limited Liability Company Act. And they should be read to harmonize within the rest of the statute. That's a canon of statutory construction. So just picking on the Berger case, Berger, if you've read it, I think it's a 2011 unpublished decision. And in that case, the plaintiff was oppressed, according to the court, in 3 ways, generally speaking, 3 ways. He wasn't getting distributions. The defendants were paying themselves bonuses while they were claiming that there was no money to pay distributions. And then the court has this line in there about, and plaintiff also was being frozen out of any participation in the management of the company or in the corporate affairs or whatever the line was. And you look at that and you say, well, is that really an oppressive act? Is being frozen out from management interference with an interest of a shareholder as a shareholder? And as you read the statutes as a whole, you see, well, who gets to actually manage the company? It's the directors and the officers. And the directors get elected by the shareholders, but they get elected by the majority shareholder. The minority shareholder gets a vote, but he's not entitled to win, and there's nothing in the act that suggests that the minority shareholder has any right to participate in the management of the company. So when you look at the act as a whole, and then you look at a case like Berger or Bromley versus Bromley, which had kind of similar holding, you say, well, wait a minute, how is this at all consistent with the actual body of the statute and all the other elements of the Business Corporation Act? And then you look at the 150 years of shareholder common law that precedes the oppression statutes, and Berger again has this line in it. It cites the Salvador versus Connor, I think it's the name of the case, for the proposition that the majority owes the minority a fiduciary duty of utmost good faith, which is well and good. But if you read the common law and you read all the common law, you'll learn that Michigan has a business judgment rule principle, and courts don't interfere with the management of corporations unless there's bad faith. And then you read, well, what is bad faith in that context? And it really has to be something that arises to the level of fraud or breach of trust. It's not any old, change of the status quo that the plaintiff doesn't like, that now he gets to say that that is willfully unfair and oppressive. So again, when you read the common law and all the stuff that people sue for under the oppression statutes, the stuff that people have sued for 150 years for breach of fiduciary duty or dissolution or injunction or fraud or whatever it is, you see that some of these oppression cases, these unpublished cases, have gone a little far afield. And from a defense standpoint, you can push back on those by pointing out that those are unpublished decisions, they're not binding precedent, and they frankly contradict both the nature of this act as a whole and the long-standing line of common law in Michigan. And then my last point on this little thing is just...
Dave, what do you think the interplay between the common law and the statute is? Do you cite to the common law to argue for breaches of the oppression statute, or can you rely on the statute to argue that it's more expansive than the common law breach of fiduciary duty cases?
I would say that, well, depends on where you are. In federal court, several of the federal decisions, Blankenship versus Superior Controls and Bromley versus Bromley, had taken the position that common law breach of fiduciary duty claim and an oppression claim are the same thing. They look at them the same, they treat them the same, they don't consider them to have different elements. In fact, I'm going to jump ahead a slide or two. Federal cases like Blankenship really seem to focus on the words unfair and oppressive, without so much focusing on the language of interfering with an interest of a shareholder as a shareholder. And to that extent, I think some of the federal cases have deviated a little bit from what binding Michigan law is. And based on Mark's question, I'm going to jump ahead in my slides, and then I'll go back. Michigan has a business judgment rule. We all know that. And obviously, if you're defending any kind of shareholder claim, you're going to want to leverage the business judgment rule as much as you can. And you're going to want to remember that Michigan has a heightened pleading standard for the business judgment rule. It's not notice pleading. Plaintiff has to put facts in the complaint to get around the business judgment rule. And again, just reminding everyone, right, business judgment rule basically says the acts of the management are going to be presumed to be valid and in good faith unless there's evidence that they didn't reasonably inform themselves, there was a conflict of interest, or that there was some element of bad faith.
Are there limitations on the application of the business judgment rule in cases where you plead fraud, and would fraud therefore be the type of facts that you would need to plead to get around the business judgment rule?
Well, I don't know if you have to plead fraud, but I think a pleading of fraud would get you past the pleading stage of the business judgment.
But does the business judgment rule even apply to self-interested actions, where there's self-dealing with the business judge? That's what I meant.
No. Interested transactions, I think under Michigan case law and Delaware case law too, an interested transaction would automatically fall outside of the business judgment rule. And that pushes, under a common law claim, the regime is business judgment rule applies unless you plead facts to get around the business judgment rule. So you plead an interested transaction, right? That's a fact that typically gets around the business judgment rule. Then the burden shifts to the defendant to show entire fairness. And if he shows entire fairness, then he's not liable, even though he committed bad faith or there was an interested transaction or whatever. That's the common law regime. I think you can make a textual argument under the oppression statutes. I've not seen this decided in any court. Someone can point me to one if they know it. I think you can make a textual argument under the oppression statutes that there's never any burden shifting, that the burden is always on the plaintiff to show unfairness, that the burden never shifts to the defendant, even if traditional bad faith is shown, stuff like that, to show fairness. Because if you look at the language of the statute, it says a shareholder may bring an action to establish that the acts are, et cetera, willfully unfair and oppressive. So there's a textual argument to be made that the plaintiff always has the burden to show unfairness. And that if you want to be in a regime where you can shift the burden on the defendant, that he has to show fairness, then you have to bring a common law claim. And you have to do it under all the old common law procedures. And if it's a derivative claim, you got to make demand and go through all those procedures. Again, I've not seen this addressed in any appellate court decision. Maybe it will be one day, but it certainly hasn't been ruled out, and I think it works within the text of the statute. So from a defense standpoint, I think that that's a powerful argument to push back against some of the traditional plaintiff side arguments that want to treat it as synonymous with a shareholder, a common law shareholder. So now I'm all discombobulated because I've been jumping around, so give me 1 second. Brian mentioned the elements. I won't spend a lot of time. I just want to point out that it's not always obvious if plaintiff actually is a shareholder. Tom and I actually had a client. Yes?
If they've been expelled as a shareholder, do they still have standing to file? Are they considered a current shareholder if the expulsion was considered an act of oppression?
Well, I think that
They get expelled.
that's going to be, I don't know how you're going to tell.
Like I had a case recently where the guy, he actually punched out the manager and stole money, and so they did a consent expelling him, and I was stuck with filing that, believe it or not. And so the question is, does he have standing?
Was he a shareholder or an LLC member?
It was actually, I'm sorry, I get him interchanged, it was an LLC member.
There's such a thing as dissociating LLC members.
Okay.
I'm not aware of expelling a shareholder against his will, but I don't know.
I just wanted to stump you.
I mean,
I needed to stump someone.
I think plaintiff is going to say, well, the expulsion was the act of repression. I think that there is I remember citing somewhere along the lines, a couple years ago, there was a common law case from wherever, where they said, well, he's not a shareholder anymore because we did X, Y, and Z. And so he can't bring a shareholder claim. And the court said, well, yeah, but what he's complaining about is that you defrauded him out of his shareholding interest, so he can make that.
I guess I don't want to give you any ideas since you're a defense guy,
So make that argument if it's wrong. Now I'm even more discombobulated. Tom and I had a client actually a couple months ago that actually just wrapped up this month, and he was a member of a family-owned business, right? These are always closely held businesses. They're not publicly traded. So, of course, no one's keeping a corporate minute book, and no one has any records. And, of course, he says, well, I'm a shareholder of this company, and I might be a shareholder of this other family company over here. And it was one of these, I was, and then I gave my interest back to my dad 25 years ago. Or maybe I didn't. I don't really remember. We didn't write it down. And it's like, well, we ended up not doing anything with that other company because he couldn't convince me. But certain unscrupulous plaintiff lawyers might have just gone right into court and said he's a shareholder, right? So, Shrewd. There also, if you look at the Patel versus Patel is an interesting unpublished case. I think it was this last June from Michigan Court of Appeals where there was a big argument about whether or not plaintiff had signed a waiver or a release of his shareholding interest and therefore was stopped from claiming that he was a shareholder anymore. So that's an interesting case to look at. The point is that just because plaintiff says he's a shareholder, there might be things to investigate to determine whether or not you can just knock that element right out. Obviously, who do you sue? Directors and those in control. The only point I'll make is that in the, I don't know how you pronounce it, Missouri or whatever you pronounce it, the court basically said, you don't get to just come in and say, he's in control, now let me get to discovery. You got to plead facts showing he's in control, because in that case, the two defendants together only own 40% of the equity. And the court said, well, 40% isn't control, and you haven't pled any other facts to show control, so case dismissed. What is oppressive, right? Franchino versus Franchino is the lead sort of defense side case. It takes a relatively narrow view of what oppression is. It's still binding case law. It's been abrogated in part by statute, but its central holding is still valid in Michigan. It's been tweaked a little bit by Matagula, but it hasn't been set aside, and that's that the interests of a shareholder as a shareholder are the interests that accrue automatically to a shareholder by dint of being a shareholder.
Do you think that's a good holding though? I mean, or is it just dictum?
No, it's clearly a holding.
Okay. Seems a little narrow.
It is narrow, but that's what the Court of Appeals said. What do you want out of me? So and here's the thing. So I'm going to pick on the Berger case again a little bit. If you look at Berger, where they basically said, well, you know, he was thrown out of any role in management of the company. Well, that really can't be squared with Franchino at all. Franchino said that, you know, okay, traditionally you guys, all your shareholders were employees and directors, but those aren't interests you have as a shareholder. So if they throw you off the board of directors, that's not oppressive. So some of these unpublished decisions like Bromley and Berger really can't be squared with Franchino. I think what you could argue was going on in Berger, because in that case, the plaintiff was also, he wasn't getting paid anything, and the defendants were paying themselves excess money while claiming, we can't afford to pay you, which is really a traditional breach of fiduciary duty style case that you see in like Miller versus Magline and in re estate of Butterfield. And it's really, you know, the decision whether to pay distributions or whether to pay bonuses is a classic business judgment, right? Which again, isn't going to apply if there's bad faith. I think what the court was really trying to say in Berger, because it deals with fiduciary duty and then it deals with oppression, what they were really trying to say is this element of freeze-out, of squeezing you out of any role in the company and not letting you have information, while we're telling you we can't afford to pay you anything, and while we're telling you that it's important we raise our own salaries, was really just evidence of bad faith. This isn't a standalone element of oppression that you can run into court because you got frozen out of management. This is an element to show that the other financial decisions were made in bad faith. That's my gloss on Berger. Who knows if I'm right, but I think that that's a way to, yes?
Can I ask a question now from him?
Yeah.
So let's say you have the right to remove someone as a director
Yes.
under your corporate governance documents.
Yes.
But there's a context of other actions that are being taken in order to silence or disenfranchise, even if that action is contractually okay or from a governance model okay.
Yeah.
Don't you still end up in issues where the motivation is at play?
Yep.
So you had the right to do it, but you were motivated to do it for the wrong reason, and it's part of the tapestry of the oppression, and therefore, Judge, it's still a relevant factor.
Yes. I think that is true, and that gets me kind of to my last point, is that, you know, defense-mindedly, you've got all your legal arguments, your business judgment rule and standing and all those things, but at the end of the day, you got to remember that these are equitable statutes, and the court is empowered to do equity, and the court is looking to apply a just and equitable resolution, and it's looking to do that under a statute that the standard of liability is unfairness. So you're dealing with equity, and you're dealing with fairness. So regardless of what all your legal arguments are, right from the beginning of the case, you know, when you're thinking about how am I going to defend this case, how am I going to answer, what discovery do I need to do, what is my theory of the case, even if it's not your burden to prove fairness, you need to start thinking about fairness, right? And you need to start thinking about how can I show that what my client did was not only legally allowed, that he had the right to do it, but how can I show that what he did was the fair thing to do, if not necessarily for plaintiff's best interest, for the company as a whole, for whatever legitimate reason you have for doing those things, apart from just, I have the right to do it. Because when the rubber meets the road and you're in front of a court of equity, or even more importantly, in front of an arbitrator, you need to be able to show that what you did is fair. Because I think in a lot of oppression cases, the court, certainly in the arbitration context where it's all a little bit loosey-goosey, they have a motivation to find oppression. They look at these guys as 2 or 3 or a handful of guys in business together. They hate each other. They're at each other's throats. inevitably, even if defendant isn't committing oppression, he's probably being a little bit of a jerk, and the court just says, I gotta find a reason to get these guys separated. So they have a motivation to find oppression, even if it's not, you know, really there. They're like, well, that's close enough, because now I can get plaintiff bought out. And that's where equity can actually help you a little bit, because the court is not bound by the plaintiff's prayer for relief. So plaintiff comes in, they want damages, they want a buyout, they want an injunction, they want, you know, defendant's house, they want defendant's firstborn son, they want the whole thing. And as a defendant, you can come in and really you should start planning for this from the beginning. If we're going to lose, if this goes badly for us, what is the relief that we can convince the court is a just and equitable relief that isn't, you know, everything in the kitchen sink that plaintiff is asking for? So if you have a case like Castle, imagine the only thing oppressive in Castle was, well, they did these things without holding a proper vote, and I didn't get a chance to vote. Well, okay. So if they didn't hold a vote a year and a half ago, and the defendant's liable for that, does the defendant now have to come up with whatever it is, $3 million to buy plaintiff out because plaintiff got screwed out of participating in the vote? Or is the more just and equitable remedy an injunction that says stop doing that, or maybe undoing whatever the transaction was that was voted on? Two more quick points on this. Parties business deal, I think, matters both in terms of liability and remedies. Even though Michigan is not a reasonable expectation test case, or state, excuse me, and even though under Franchino, you know, what is a shareholding interest is actually fairly narrow. When you actually get to litigating it and the rubber meets the road, I think your finder of fact is going to be interested in which of these parties is departing from what the deal is between these parties. Because even if they don't have a written shareholders agreement, you know, they got together, they formed a business, they had some sort of business arrangement that they were working under. Whichever party is departing from that business arrangement is probably the one that's going to look like they're being unfair. So if you're the defendant, you want your argument to be more than, well, I have the right to do it. Look at the operating agreement. We're the majority, we can do it. You want your argument to be, here's why it's fair that we did that. And then the last piece is, you know, you want to watch your client. What is he doing during the case? Make sure he's not digging himself a deeper hole. If he got sued for stealing money, you shouldn't steal more money while the case is going on. If he got sued for if he got sued for paying too high of a salary, he shouldn't give him a raise because it's January, I get a raise in January. And even in the nitpicky freeze-out things, you see it where plaintiff says he's frozen out, defendant talks to his lawyer, he hears about Franchino, he says, oh, I can do whatever I want. You know what? He's not working in the company anymore. I'm going to take away his company's cell phone and his company life insurance because that'll save me $1,300 a year. And you look at it and you think, really? You're in front of a court of equity and now you're going to, you know, make yourself look like an even bigger jerk and you're going to ramp up the aggression to save $1,300 a year when if you just acted rationally for another 3 months, the case will be done. So hopefully your client comes to you before they make those decisions, but you want to counsel them that now is not the time to ramp up the aggression against the plaintiff. Regardless of whether or not you think you're right on the law, you think you're right on the equities, you want to make sure you look good in front of the court of equities. You want to look like you're the fair and reasonable person. So
that's actually a good point, because in Castle, even though the capital calls were held to be illegal in the Court of Appeals, the majority control group in that case, while it was up in the Court of Appeals, continued to issue capital calls by consent, and then was actually so aggressive that they filed a separate lawsuit to enforce the capital calls, which, under the law of the case, were held to be unlawful. And so it was sort of that interesting dynamic of pushing the aggression, as you're in the case. And ultimately, I think it backfired because we supplemented the record in the Court of Appeals with that material. And,
that's where the stage when the lawyer for the defendant, I think, wants to take off his advocate hat and put on his counselor hat and tell his client, look, yes, we have all these legal arguments, but we haven't won those legal arguments yet. So why would you make yourself look worse to the court than you already do? Because you might lose, and now you're just making it worse on yourself.
Thank you, Dave. Oh, yeah.
Well, it's not unlike a divorce case.
No, it isn't.
I mean, the judge in an oppression case has equitable power.
Yeah.
A judge in a marital divorce case has equitable power.
And that's true.
And from the defense standpoint, when you're defending those cases, it's like the divorce case where the husband is alleged to have abused the kids. So you can't abuse the kids during the case. And it drives them crazy. Because they can't even do what they're entitled to do because it looks bad.
The last oppression case I tried, when Tom was with me on this one, we were in front of an arbitrator, and we were on the plaintiff side in that case, and we did win. And I was talking to one of the arbitrators, and this was a 50-50 business, and the arbitrator said, well, you know, we looked at it, and we realized pretty quickly that the objects of matrimony could no longer be achieved between these parties, so there was no question we were going to separate you. We were just going to figure out when we're dividing up the marital estate, how do the equities work on that? So it's just like a marriage, especially when it's 50-50.
And it's interesting you say that, because I have given thought to the concept of whether it should actually be structured along the no-fault logic that we see in the divorce cases, which is one side can basically call in the marriage. It doesn't take two sides anymore. And it could present some problems, but I actually believe that bright lines in the statute actually motivate good corporate governance in the beginning, because if you know you can have a brutal outcome by virtue of what the statute allows for, then it should facilitate that. But that might be a little bit too extreme of a view. And it's nice to hear two completely diametrically opposed views on what oppression consists of as we segue into, is it Tom who's next?
Yeah, I think so.
Yeah, okay, thanks. And Tom's speaking on the valuation issues in oppression cases.
All right. Good evening. Quick background: I'm a numbers guy, CPA, that kind of thing. I've been doing shareholder oppression cases for 20+ years, and I think I know most of you in this room because of that. So anyway, good to see everybody. What I'm going to talk about a little bit tonight is valuation issues, and I'm going to talk about some of the things that I've thought about in different cases, certainly not fully been resolved, but things that I think are relevant when you start looking at the question of how to value an interest in one of these kinds of cases. And just to get started, because I do not want to bore anyone, other than Paul, how many of you know enough about valuation to be able to talk for 2 minutes straight? Okay, all right, good. Actually, that's better than I thought. All right. So basically, when we talk about valuation, I'm going to talk a little bit tonight about approaches and methodologies, but one of the things that I think is frankly frustrating for people in my profession, but also for folks who are on the bench or are practicing, is they look at two experts who come in with an opinion on value. One is saying it's worth $10, the other is saying it's worth $1,000, and the fact finders or the advocates sit there and accuse one or the other of being an advocate, or other words that start with similar letters. And so, and I want to, I guess, in very simple terms, talk about a little bit tonight about why. Why does that happen? And I think one of the things Paul brought up right out of the gates tonight, which I really think is part of the answer, is what is fair value in Michigan? That's a definitional question. It's a phrase that is relevant to someone in my profession. A lot of times you'll hear fair value, and then in the next breath or the next sentence it's fair market value, and what's the difference between those two things? And so that's an example of one sort of reason why appraisers can come in with a very different conclusion, because one defines fair value in a certain fashion and someone else in a different fashion. I also want to talk about the valuation date. Quick war story on that. If you have a case that's typical in this space, goes for 2 years, something like that, between the time that the bad act happens, the complaint's filed, and the time you get to trial, lots can happen in that time frame. So one of the basic questions is, well, what is the valuation date that appraiser should be focused on? Is it the date of the complaint? Is it the date of trial? There's a lot of things that go on in the meantime. And you can have, again, very, very different outcomes if you look at one versus the other. You know, a case I had a number of years ago involved a company that owned a lot of commodities, very volatile inventory values. And so if you looked at their business value on the date of the complaint versus the date we went to trial, huge differences. And again, whose fault is that? It's the appraisers. The third topic I'll cover quickly is the size of the interest. So when you ask an appraiser, okay, come in and value this minority shareholder's interest, whether you're on the defense side or the plaintiff side. First question is, well, what does that exactly mean? Am I valuing the fact that it's a 20% interest with no rights of control? It's in a closely held company, because by definition that's the only ones that the statute applies to. And so the question becomes very quickly, am I valuing just this interest with none of its rights and all the limitations and such, the buy-sell agreement limitations? Is that what I'm valuing? Or do I take a step back and do I value the company as a whole and then multiply that conclusion by the 20% that that plaintiff owns? And so an important issue, and again, another war story. This comes up and can be very explicit. The two appraisers sit down. One says, I'm valuing the 20% interest. I'm going to apply discounts for lack of control and lack of marketability. That means an off-the-top 40% haircut on the value of those shares. The other appraiser says, no, that's not appropriate. I put 0 discounts on there. That's a very obvious difference. But what happens if the appraiser who is looking at this as a minority interest says, no, wait a minute, I'm not going to apply any discounts. I'm just going to continue to assume that all the stuff that that plaintiff is complaining about is going to continue forever. In other words, the controlling shareholder is going to pay themselves exactly what they've been doing for the last 3 years, which is why we're in the lawsuit in the first place. Huge amounts of compensation going out, very little left for the shareholders. Value is minimal. Well, the reality of it is that assumption that that appraiser is making is reflective of the fact that the minority shareholder cannot change the controlling shareholder absent relief from court. And so it's an example of a situation where the appraisal methodology or assumptions can actually build in to the conclusion a very large discount, which would be appropriate for a closely held interest. Another thing I want to cover quickly is going back for a moment to the fair market value versus fair value concept. There's a statute in the state that talks and actually does have another phrase that says fair value. It actually does have some definition to it, and it basically talks about the idea that if you're charged with determining fair value, you are going to determine a pro rata value of the entity the moment or the day before the event occurs, which triggers this need to perform or determine fair value. That's done a lot of times in a corporate squeeze-out situation where a controlling shareholder makes an affirmative decision that says, I am going to push the minority shareholders out legally. I have an obligation to pay them fair value. And so there's a process there. An appraisal is done and then this definition is applied. So, great, fair value is in another statute. Why doesn't it come up more often in this shareholder oppression statute or member oppression statute? I think the answer to that is unknown at the moment, but it does come up. And I think just in terms of one additional point on that is that when you talk about fair market value, which is a term that's widely defined, it's covered in a number of different cases. Internal Revenue Code is filled with references to fair market value. Fair market value is reflective typically of a definition which is a willing buyer and a willing seller, neither under compulsion to buy or sell, and with knowledge and all kinds of other things as well. But is that really what you have in the context of a case where you're alleging oppression? Do you have a willing buyer or a willing seller or both of them, or do you have half or neither? So that question comes into play, and fair market value versus fair value is part of that analysis. So let me move on to methodology issues, and I'm going to again keep these sort of focused on why you end up sometimes with appraisals with very different conclusions. So first of all, there are 3 basic methodologies in evaluation process. This one that I'm speaking of now is the income approach. Fundamentally, what it does is it focuses on what an owner could expect to receive as a return on their investment in the future. It's forward-looking. And the appraisal process typically starts with someone like me looking backwards. So let's see what the company did last year and the year before and the year before. That's relevant, obviously, though, for the intention ultimately of forecasting a stream of income, which then is used to determine value. But in terms of the next step, and this is where the fundamental issue typically comes in, is what's called a set of normalizing adjustments. So these are things that, simple examples would be If you made a lot of money last year because you received an insurance reimbursement because one of your machines burnt down or something like that, that's easy to understand. It's removed or eliminated in a normalization process. But ultimately, the thing that comes up in almost every single oppression case that I'm involved in is some allegation that one of the normalizing adjustments that needs to be made is to adjust the behavior of the controlling shareholder. For example, excessive rent, excessive compensation, maybe a diversion of a business opportunity that's causing profits at the company you're talking about to be depressed or sometimes enhanced. But that's the kind of question that comes up. And so the question then becomes, what's normal? And how do you sort of determine that? David mentioned earlier the business judgment rule. That is one of the things that is brought up on the plaintiff's side and the defendant's side when it comes to the question not only of defending for liability purposes, but also for determining the normalization things that you would do for purposes of valuation. We'll talk in a few minutes about another concept that comes into that normalization, but the next point I want to talk about quickly is the second sort of main component when you're applying an income approach is to look at what's called the risk profile associated with that business. You're looking for an investor's assessment of risk and growth opportunities at that business. And sometimes if you've heard business valuation conclusions expressed, or you've heard even if you watch a cable program that talks about business valuation issues, you'll hear people refer to multiples. A PE multiple is a price to earnings multiple. You'll hear other folks talk about an EBITDA multiple, which is a measurement essentially of cash flow. And the interesting thing here, to be frank, is that, again, many times an appraiser who is asked to look at and determine an appropriate multiple can come to a very different conclusion if they look at that business and say, okay, based on the way that the existing owners are running this thing, maybe the risk and the growth options are very small and limited. Maybe it's going to be steady Eddie business, very conservative capital structure, no debt, all equity, it's going to go right along. But that may not, in fact, be anywhere near the idea of maximizing your financial outcomes if you're an owner. In other words, if you transferred that ownership from the existing group and you sold it to anyone else in the world that had a financial perspective, they may say, wait a minute, this is absolutely being handled the wrong way from a risk profile and from a growth profile. We need to be doing certain different things. And that can, frankly, dramatically affect the multiple that one would apply. Another example or another issue relevant even under an income approach is consideration of a balance sheet. Real simple terms. You're looking at things like how much debt is on the balance sheet at the time you're valuing the company, how much cash do you have, how much working capital do you own, do you have a pension liability, those kinds of dynamics. Again, why is this relevant, particularly when you read two appraisal reports? One of the most critical concepts out there is that you can have certain owners who will run their business very, very conservatively, others very aggressively. That affects the balance sheet. And so when you begin to look at sort of what kind of normal things should you see on a balance sheet and compare that to what is actually there, that can really be something that an appraiser focuses on and makes an adjustment for. All right, asset approach, second sort of major one. I'm not going to cover this in too much depth because, frankly, this approach is typically not used. But I'm sorry, it's not one that's ultimately a source for reliance from an appraiser's perspective, especially if it's an operating company. Real estate holding would be a different story. But basically, the focus of an asset approach: tangible stuff, the things you can touch and feel, receivables, equipment, buildings, those kinds of things. And it does, though, become relevant even for operating companies when the performance of the business itself is poor. Okay, so for example, if I have a gold mine that produces $20 of profits every year, but there's $1 million worth of gold sitting at the bottom of that mine, the realistic approach to valuing that mine is to value it based on the gold inventory that it has, even if someone has chosen, for whatever reasons, to mine it slowly. Okay? So in a more common sense, what happens when you have an operating business that is, let's say, capital intensive and making very little money? What do you do in those situations? And frankly, what can come up in those valuation discussions is whose fault is that? You know, if you're not making any money, you've got $50 million of assets sitting there, you're not really making any money, is that because you don't know how to run the business? Is it because you're being oppressive? Is it because you're conservative? What are the things that go into that? And then how does that affect, you know, sort of that decision ultimately that the appraiser is making with regard to which valuation approach to rely upon? So it comes up. All right, let's talk about oppressive acts and sort of the interaction with damage claims. As has already been covered, there are multiple remedies under the oppression statute. Those remedies include an award of damages, and they can also include an award of for the fair value of the stock of the successful plaintiff. What's interesting is these two concepts, in my view, overlap, and I am not an attorney, so I'll say that up front. Maybe I'm wrong in saying that, but damages, in my view, can overlap with this question of fair value, and I'll give you an example. If you have an appraiser who concludes that the appropriate date on which to value the interest is right now, at the date of trial, 2018, and you have the other appraiser who says, oh no, I think it's back in 2016 when this case started, that's what we should be doing. The question becomes, how do you handle the 2 years that has passed in the meantime? Maybe the value of the business has gone up, maybe it hasn't. Maybe that's because of a controlling shareholder, maybe it's because of market forces. There are all kinds of issues there. But in those situations where the issues are things that you're complaining about, to the point that was made a few minutes ago, maybe you should stop certain activities while the case is pending, or at least don't escalate them. But in any event, let's assume, and I use the example here of distribution starvation, let's say for the 2 years while this case has been pending, 0 dividends have been paid out. Okay, fine. Plaintiff is not happy about that, has brought suit because that's the continuation of a long-term practice. Guess what? If you don't distribute dividends and the cash instead is building up inside that company, is that such a bad thing for value? Some parties would say yes, some would say no, but that's an example. So you may have a scenario where you've got a claim for damages that relates to something that also interacts with your value. Yes.
In terms of the timing of the buyout of a shareholding or a membership interest, how do you avoid the perception that it's not just a self-serving selection of the most advantageous date, whether it be the payor or the buyer, the paying party choosing, you know, and they always happen to pick the lowest date, and then the receiving party is picking the most advantageous date when it would be, you know, when the shares should be valued. And in connection with that, you know, avoiding the perception, at what point in the process do you think that the shareholding date should be fixed? Because I've struggled with this. Is it way down at trial when the judges, the bench is getting ready to decide the buyout? Or should it be at the beginning, and should it be something that actually might be fixed by statute at some point?
That's a great questions, plural, a great number of them. Yes, I think the answer, you know, I think there's a couple of different dynamics that I would think about. One is just the broad idea of equity. And frankly, the longer a trial goes, or I'm sorry, the longer a case goes, the more difficult it is to determine why the business's value has gone up or down, or why it's making more or less money. Frankly, you know, sometimes, or many times, when a plaintiff sues, the next thing is that they're no longer going to be working at that company, and that can have an effect on the company as well. So, in other words, you fire your lead salesperson, that's going to affect typically your sales, although sometimes I'm sure there's allegations that it was a help. But I think the point is fundamentally the longer and the more issues that come into that equation while you're prosecuting the matter, the more difficult it becomes to unravel. I think as a second, you know, a secondary consideration there is if you really think about the idea that you've got a lottery ticket as a defendant. You've been sued. If it turns out great and your business improves in its value, your argument is, well, buyout should have happened back here in 16 when this whole thing started. And if it doesn't turn out great, then you are arguing the opposite. But you kind of have control of that while the case is going on. So I think, you know, again, that's a sort of a core judicial concept or fundamental fairness concept, I think, that frankly goes into play with many plaintiffs and many defendants in cases that have nothing to do with shareholder oppression. I think that that's one of the dynamics you got to think about. To be blunt, I don't think there is a black and white line. Okay, so those are some examples of the kinds of things you might look at. Again, one last point I'd make on this is just that you have, when you think about damages, one of the things that I try to do is look at it and say, okay, those damages typically fall within a time period that usually can be measured as of the date of trial. So in other words, they are past damages primarily. The valuation, if it's done as of a trial date, then makes that plaintiff whole as of the point in time when that value is determined. All right, I'm going to skip through those given my timing here. All right, so I have 5 quick questions that I wanted to sort of throw out there. I don't know that I have all the answers, but these are things that have come up. So first, which is an important one I think that may be coming up here in a minute, is does a finding of liability create liquidity that wouldn't otherwise exist? So for example, buy-sell agreement is in place. It says you get to get out if you die, if you're disabled, if you want to quit, if you get a discount. You know, there's all kinds of mechanisms that give you liquidity. And if you're a minority shareholder and you approve oppression, you get to basically walk away from those things. Maybe they were punitive, maybe they were helpful to you, but do you get to walk away from those limitations and basically create a market through the court's decision about what's equitable? Do you get to create a market that gives you, you know, a defendant would argue a windfall. A plaintiff would argue it gives me what I always deserved anyway. All right, question 2. Should contractual mechanisms interact with fair value definitions? Okay, example. Someone's going to talk tonight about the idea that your buy-sell agreement should be drafted as soon as you get started with your business partner. And I tend to agree with that. If that agreement says hire an appraiser or use the formula that says 4 times EBITDA is the way to value the company, great. So now you don't get along, you're 5 or 6 years down the road, are you stuck? Should you get 4 times EBITDA if you're successful in showing that you were oppressed? And I will say this because people ask me to help them draft those types of provisions, that sometimes when you are drafting those provisions, you build into that formula the idea that it's a minority shareholder. That in fact, maybe it's not really fair value, it's fair market value when you put that formula together. So something to think about. Number 3, sorry. Death by 1,000 mosquito bites. I had 2 occasions this year to go outdoors and just get eaten by the mosquitoes. I know what it means to get eaten to death. But in any event, so here's an example, step transactions. The Franks Linkner case was an interesting one to me because I think one of the things that it opened the door for was this very simple argument. Hey, we changed the operating agreement, it contains this provision that says you can be diluted upon the following events. Oh, that's wrong, I'm going to sue for it. Okay, what are your damages? Anybody that you hire like me is going to be accused of speculating because the damages haven't ripened. Where are you at? I think at the end of the day, you, as a controlling shareholder, have some new options there in terms of your planning. So, in any event, that's just an example of, you know, it happens one step at a time, one bite at a time, just like with the mosquitoes. Should non-actionable decisions be considered or ignored by an appraiser? Again, let's say you have a corporate agreement. It puts some ridiculously high or ridiculously low amount of compensation in. Everybody agrees to it up front for whatever reasons. Does the appraiser, making the normalizing adjustments, ignore that portion of the agreement, or do they build it in? Somebody brought up earlier the idea that maybe you're stuck with the agreements that you execute. The equities of them should drive the equities that the court considers. Again, very, very clearly no direction on that for appraisers at this point. And the last one I'll bring up is kind of one of my favorites. So fair value, when is it applicable? It's applicable for a plaintiff who proves their case. If they don't prove their case, they don't get to that remedy. So when you have 2 appraisers who are sitting down to talk about value, and the plaintiff's appraiser says this is fair value, and the defendant's appraiser says I came up with fair market value, my question is, why is that relevant? Why is fair market value at all relevant to the question here, given that that's not actually a remedy? And number 2, given that a remedy for a buyout is only driven by one plaintiff who is successful. again, this I think gets to a point that David just made a few minutes ago, which is that, especially I think in an arbitration context, you may want to present your fair market value argument because at the end of the day, if they want to find some way to make the parties divorce, go their separate ways, and they need a number, the fair market value option, even though it's not technically a remedy, is where they may be interested in going. Did I get through fast enough?
I think you did.
Okay. All right.
Thank you, Tom.
Thank you.
I've worked with Tom for about 15 years, and the thing I like working with him most about is that he never hesitates to tell me when I'm wrong, which is a lot more than I'm right on these matters. So, and I appreciate you speaking here tonight, Tom. And the next speaker is Larry Lee, and Larry is going to discuss some issues pertaining to forensic discovery and e-discovery in these types of cases.
Thanks, everybody. Actually, I've got my slides up here, but I wanted to see, do we have the actual a copy of the evidence map and the Excel spreadsheet I can refer to, or we just have the slides? I've got a copy on my, okay, we just got to do the slides. So basically, our best practice at the beginning of literally every case we get engaged on is to create what we call an evidence map. And we have a standard Excel spreadsheet with multiple tabs. We can distribute it to anyone who wants a copy. But we're interviewing clients first up front. We always ask, what is the relevant time period for the dispute? It's never forever. Maybe, for example, the parties first met for the first time ever, January 1, 2010, and then a complaint was filed on December 31st, 2015. That would be the relevant time period. And during that, once that's been defined, that's the first place to start, the only place to start, in our opinion. Then we're going to go and look at and identify what are all the physical sources of potentially relevant evidence that exist or existed during that relevant time period. Personal computers, email accounts, email servers, business systems, thumb drives, phones, etc. And we have a very nice a list, an actual questionnaire form that we go through when we're interviewing folks. And the reason we always take this approach is there's multiple reasons. One, our clients typically don't know. I'll say that the counsel is not provided. The corporate client, the litigant, does not provide their counsel, outside counsel, with a robust amount of information up front. And so what we want to and need to do is identify, again, and draw a black line boundary around what are all the physical sources of potentially relevant evidence to this dispute. And what our deliverable at the end is then what we call an evidence map. And it allows our client's counsel to go into meet confers early on and say, look, given what we knew about the dispute at the time, here are the steps we took to identify and preserve potentially relevant evidence. After we've done this evidence map and drawn that black line boundary, that allows our clients to then identify sources that, for example, are not reasonably accessible due to cost. They might discover a giant box of backup tapes that would cost $100,000 just to restore. This comes up all the time where usually it's the counsel, the attorneys that are hiring us saying, well, we've sent the corporate client an email saying don't delete or destroy anything relevant to this suit, and isn't that enough? And our experience is that is absolutely not enough. So our best practice is actually to document in our evidence map the sources that have been identified and actually that have been preserved. And in our opinion, that's a much more robust and defensible litigation whole process. Also, by identifying and drawing this black line boundary around all the physical sources of potentially relevant evidence to a dispute, it allows the parties to, or want to, quite accurately forecast discovery costs, because we're going to be collecting these 5 phones, these 6 email accounts, these 3 computers, and we have a robust cost model that's highly accurate that will multiply out by e-discovery costs, computer forensic costs, attorney review costs to collect identify, review, and produce documents in discovery. And we can accurately forecast that based upon the evidence map. And then finally, oftentimes I'm asked to write an affidavit or declaration describing the steps we took to identify, preserve, and produce electronic evidence. So now I've got the. I wish I had the. I have a copy on my other laptop. We do want to provide everyone with this template. But again, in the Excel spreadsheet that you'll see, we'll just Sean, we can email it to everyone. I'm assuming we have everybody's email addresses. Again, on our evidence map, when we're interviewing custodians, we call them custodial interviews. We first record the relevant time period of the case, the person, the time, date that who I'm interviewing. We will typically, so the outside counsel said, well, do you need us to be accompany you for these interviews? Oftentimes we don't need that information, but we'll be asking our client, as you'll see in our Excel spreadsheet, we'll say, what's your current computer, make, model, and serial number? When did you actually buy it? When did you actually start using that computer? Why do we ask that? Well, oftentimes it's the case that they go, oh, well, I just got this one new 2 weeks ago. Oh yeah, the one that I was using during the 2010 to 2015 time period. Yeah, that's sitting here gathering dust. We still have that, or it was, we gave it to another employee, or it was wiped or destroyed. We'll ask about their current phone, email account, cloud storage, paper discovery, and basically all of the sources that from our experience, people potentially could have relevant evidence. This last piece, this is the part that it's when our clients actually will sit down with us and tell us where they keep information related to the dispute, then the discovery process seems to inevitably go very well for them, particularly from a cost perspective. I'll be interviewing engineers, and they say, I'm very organized. Here on my computer, I've got a top-level folder called projects, customers. Now I've got 100 customer subfolders. Now here's the one that's the subject of the lawsuit. Now if we go into that folder, now we've done 20 projects for that customer. Oh yeah, there's the one project that's the subject of the lawsuit. We actually ask for that path. We say that, okay, great. Now we can just target surgically, pull that information out, provide it to counsel to review. All the other projects, irrelevant. All the other customers, absolutely irrelevant. In fact, it'd be a disaster if that inadvertently got produced. This seems to be a big struggle to actually oftentimes get the corporate client to sit down with us and tell us where the specific information resides. But it is the best path to inexpensive discovery from our experience. We've got another tab on our Excel spreadsheet map for you folks. We call it structured data sources. So that's where we're identifying the business system, so email servers. So, and this is typically how it goes. So if the relevant time period is 2010 to 2015, I'll say, okay, what's your current email system? Most corporations are moving to Office 365, so they're now in Office 365, but maybe they just moved there halfway through that 2010 to 2015 period. And I go, okay, well, what were you using from 2010 to 2013? They go, oh yeah, we were on we had our own Microsoft email exchange server. Oh, and we still have that server, and it's sitting over here, and we still have that. We haven't returned it. Typically, in our complex cases involving 10, 50, 100 plus employees, it is most often the case that not all employees will have been migrated from the legacy, let's say the in-house email exchange server, to what's now their Office 365. So we need to identify that. We need to map this out. What's their current email server? When did the client start using it? And was there another email server system, maybe Lotus Notes, or an internal like Microsoft Exchange server, or a third-party provider that was used during the relevant time period? And if yes, were all the custodians of interest actually migrated over? And inevitably, typically corporations will hire a consultant to perform this email migration, and they'll have records of which employees they migrate over. It is standard practice for companies not to migrate over from the locally managed Microsoft Exchange email server to Office 365 employees that are no longer employed.
Aaron,
So-
can I ask you a question? How do you deal with situations, and are there products that are available in the discovery context to get us over some of the cost prohibitions? Because this kind of e-discovery and forensic discovery, it's a no-brainer in the larger scale cases. And what I find sometimes is that it tends to be something that it should be done but isn't done because of the cost of it. And I would just be curious if there's different products that can be employed in this context that allows some level of forensic investigation, because in this day and age nothing's more important in the discovery process. But, you know, it
Yeah,
doesn't have the sticker shock of a
No,
loan.
the answer is absolutely. In fact, that's what I was doing today. So we have a CLE class called the Electronic Evidence Locker. So it's free software. It's called FTK Imager. It allows our clients to go in. Yep, I got another time. And go in and you can make a forensic image of a server or a computer. And then there's a tool we employ called it's not our software. It's called Size Explorer. Size Explorer. It's $29. So once we create that forensic image of the server, Size Explorer will then make a searchable index of it, and our clients can search. So I'm working on a case right now. Our opponent had defrauded my client out of $100 million. They planted someone very high level up in our client, and so I collected it's a 6 terabyte server. And so I went to the client, so that was just a day of me going there. And we took the Size Explorer tool. I was at their offices today. I said, here's the server. I use this FTK Imager tool, it's free. Mounted this forensic image, connected to the Size Explorer. They bought it. The law firm's Wayne Morris, a great referenceable client, and now they're able to search through that entire server. They're now going to be conducting custodial interviews to say, okay, for the projects in dispute, where did you keep that? They're just going to do a screen share and go right here. Again, it's the bigger challenge is actually getting the corporate client to participate, say, oh yeah, for this project, here's where we kept our, the CAD drawings, here's we've got subcontractor, general contractor invoices, and here they are. And then I showed the client with this FTK Imager tool, I don't know, it's Access Data, you can then extract out from the forensic image. Just right-click on the folder that the custodian and just right-click out and export out a forensic image file. Our clients have just produced those as is. There you go. It's a true bit-for-bit copy. The original metadata is all maintained. And so this guy named Jeff Maris, very sharp guy, he says, oh boy, we can just bypass the whole relativity thing. So that actually cuts out, that cuts out a big chunk of our revenue, but it's the right thing to do. So it's just more of, will the clients, sit there and work with us and use the tools? So Size Explorer and FTK Imager are killer. Another one is OS Forensics. It's by a company called Passmark. It's an Australian company. It's a law enforcement military sector tool. It's about $800, but it will create a complete searchable index of everything, even beyond what Size Explorer does. And it basically allows our clients to completely bypass this whole e-discovery. So there are other free tools out there. So the short answer is yes, just knowing what the tools are. That's a great question. Let's see, the timeline tab, you'll see on there, we always, recording times and dates of interest, activities of interest, keyword phrases. Oftentimes we're provided with keyword phrases. In most cases we're not, so I'll go through the complaint, other interrogatories, pull out, critical people's names, cell phone number names, email names, projects of interest, companies will use code words. Again, because with these tools like Size Explorer or OS Forensics, we can just quickly identify, in this massive corpus of data that we preserve, here's the 5 folders. Right? People always tell me this, they go, well, gosh, when it gets to trial, it comes down to 12 pages of paper, right? Why are we going through all this junk? I'm like, yes, I get that, but corporate client, will you sit down with me in your counsel and show us where that is? What's relevant, so we can at least start out with, what that potentially relevant information is. When that happens, from my experience, discovery goes very well and their cases go very well. And that's basically, any other questions or? That was it. We'd like to give you guys this Excel spreadsheet. We think it's incredibly valuable.
You know what, and if you could actually email me a copy of that, there's some other people who want material from this.
Okay.
If they're not here, they don't get it. All right?
Have we give you a link to the application during size explorer?
But Lee and I.
We know a lot of pro bono cases, so we have to rank all the tools ourselves.
Yep.
And they're believe me, they're out there. There's
Yep.
free tools that work extremely well.
Okay, well, thank you very much, Larry, appreciate it. And Brian is going to briefly tell us how we can avoid having to get to the point where we're taking e-discovery. So, Brian Reeder.
Sure. Thank you guys for being here tonight. I might try to set a record for like the quickest presentation because I think we're all here to see Jake's over here listening to what he has to say. And some of this maybe sounds like sunshine and rainbows because yes, corporate documents, great, get them beforehand. Everyone sits around and put everything on the table and we sort out all the issues. And when I got the topic, I realized that it seems like this specific topic sort of takes away all the business that you guys do, right? So if everybody had great corporate documents, we wouldn't need judges and lawyers and evaluators and things like that. So I'll be sensitive, but I think some of this goes along with my new business and estate planning as well. And so as an estate planner, you think of everything on the board, and as a business attorney, I think of everything across the board as well, sometimes too much. But I think as a rule of thumb, get the documents formed before the company is started, sit down and beat on the clients a little bit. Don't just start a company because, oh, you have this new corporate client that comes to the door and they're willing to pay you, $500 or $1,000 to form an LLC or to form a corporation, and then just sort of move them along and onto the next client. These are important clients and important people, and it's our duty as an attorney to make sure that we serve them properly and help them dot all their I's and cross all their T's and sit down and counsel with them and not just think of it as, it's not Walmart, just next, and just keep running them through because we're doing them a disservice and giving them to you guys to do the valuations and to litigate. And I've actually taken the stance as a business attorney is I will, if it gets to the point where they're just not agreeing, I won't form the corporation. I won't help them do that because I think it reflects negatively on me as an attorney and my duties and rights under the professional code of conduct. I will either assist them in getting them to a different attorney, but I've really taken a hard stance on that. And although it's difficult to get through, and there's a number of issues that have to be addressed across the board. We've talked about a lot of them today, with valuations, with buyouts, with alternative dispute resolution, percentage of shares, either majority or minority, how to avoid things. I really have tried to impart upon them the importance of getting these issues resolved right from the outset. I think many of us have heard it before. You either pay me a little bit now, or you're going to pay me a heck of a lot later, and really sort of not force it upon them, but educate them and counsel them as best I can to do that. And the other part of that really is for them to understand that this is a living document. Your bylaws or your operating agreement's a living document. Every decision that you make should be run through your operating agreement or run through your bylaws to see what your rights are, what your duties and responsibilities are, how that impacts you as maybe a majority shareholder or a director or an officer, but also how that impacts the minority. And even if it's a big enough decision, talk to corporate counsel, run that by corporate counsel before a decision's made, or let's get together and have a meeting before a decision's made. Also an advocate for monthly, if not quarterly, shareholder meetings, so everyone's on the same page. There isn't although annual meetings are important as well, but just to keep on topic, up to speed with everyone, review financials as best you can. Don't get too far in the weeds, but at least meet with each other, discuss issues that are going on in the company. Even if it's a minority, even if it's a 5% shareholder and a 95% shareholder, treat it as you guys are making decisions together to keep everybody involved. I found that is best practice across the board. And going back to those documents too, not to make everything so boilerplate, anyone can find a sample operating agreement on the internet, right? Even though my favorite other clients will come in with the ones they've copied and pasted from Google, like California, it's an operating agreements or bylaws, and they're like, hey, can you just tweak this? And that's going to take 20 hours for me to do that. Probably just start with. So we give them a checklist and have them go through and identify those certain issues that may come up. But really put a good, solid framework for them to start their business. And although it may be a little more expensive than they were anticipating, once again, it goes back to, if you guys are serious and you have experience in business and you're committed to starting this business, you have a great idea, it's going to be a bit of an investment. But if this is a good living document that you can, under contracts, you can look at and say, gosh, here's what I have to do, here's what I'm responsible for, and it works pretty good, maybe 90–95% of the time, great. Then every time you look back at that, you're saving money because you're not hiring evaluators and $1,000 an hour attorneys for litigation.
You should have, you're talking. You should have your rate out of that.
Let's talk about how we can get those rates up there.
No, but yeah, once again, just as a general rule of thumb, probably more about a couple of years. But that's really it. Just sit down and counsel your clients if you're doing the business formation side of it. Even if you get a little bit late into the game, which is, it gets even harder if they're 1 or 2 years down the road before they have a buy, sell, or operating agreement. Just bring them around, counsel them as best you can. Sometimes it's impossible, but try to get most issues resolved. What I see that I do is I eliminate a lot of the ticky-tack issues that you guys don't even like to deal with in the first place, and get to the bigger ones about valuation and shareholder buyouts, as opposed to potential issues, not that it's ticky-tack, but if there's a capital call issue, let's just resolve it from the outset so that we can move forward and run the business. Yes, sir.
So, to our conversation we had before the event started, how do you, when you have a client that comes to you, 2 guys or 3 guys or whatever, they want to start a business and they're best buddies and they're going to go to business together and, make $1 million a day, and then you sit down and tell them, well, they got to have agreements. How do you deal with the, when the client's like, well, why are you harshing our boss? Why do we got to, why are you making us go through formalities when all we want to do is make money and be best friends forever? How do you deal with those guys?
Give them a few examples of where, just from experience, of where
They can never stop being friends.
Everyone
We're great.
just tell them straight up, because in 6 months you may all hate each other. Family members are the best when they come in, my brother and I want to start a business. Please don't start a business. But really just giving them examples. If they're dead set on, I want to start this company, we're going to be great, that's fine, and just go through all the risks and things that they could run into and try to educate them as best you can. You can't force them into making a decision either way, but if I find that's too contentious, then I won't form it. But there are those cases where, hey, yeah, 3 college buddies want to start Apple company. Attorney for Apple, and they sort of came with many times. But yeah, it's just important to advise them as best you can of what they're supposed to do, what they can and cannot do, and sort of let the chips fall where they may.
And to not use the agreed upon value as Exhibit A that we're going to update every year. That they never.
What percentage of your clients do an Exhibit A? Just do it the first time.
I would say I actually have the very first time. Quarter maybe less. I have one client who does it religiously. We have annual meetings religiously, and they have like 8 different companies with me, and they get it done every year, and it's perfect, and it's great. And if there's ever a shareholder buyout, which there has been a couple, we know the value is perfect for that.
Yeah.
But the other ones, I love going through the operating agreement or bylaws and going, Exhibit A, you're supposed to have a value, there's nothing here. Okay. Then we call guys.
Well, Google didn't have Exhibit A, so.
It gets pretty dicey, but no. So have good corporate documents. If you don't, then give them up to guys. If you beat them up, help through the process.
We'll sort it out.
Yes.
Thank you, guys.
Thank you. Thank you.
Thanks, Brian. And I had a thought that escaped me that's probably for the best. And we'll get on with things and have Judge Yates take the podium and tell us how we should do our jobs.
Well, first of all, I don't have a whole heck of a lot to say. Let me start with a few broad brushstrokes and then bring it down to the more granular level. The most basic point, I think, is that there is not yet a well-developed body of law governing shareholder or member oppression, and it's no accident that that's happened. Judges typically like to operate in their comfort zones, and dealing with business cases for almost all the judges in the state is not within their comfort zones. Most of the people who have substantial experience in commercial litigation can't take the pay cut to become a judge. And if you wonder how you become a judge, I mean, I had an intern once who said, boy, you have the perfect background to be a judge. No wonder they picked you. And I said, no, the reason they picked me was one of my first jobs out of law school, I was a federal prosecutor, and I happened to have an office right near somebody and became really close friends with somebody who became the governor of the state of Michigan. That's how you get it. So if you're looking for a deep bench that's comfortable with complex issues of commercial litigation, you're going to be waiting a long, long time. Now, that leads to an unfortunate fact of life for all of you, and that is that most of the opinions in this area are not published. And the few that are published often aren't especially well-reasoned. I have my own vanity press. I've got a website, I'm just supposed to publish my opinions. There are about 450 opinions out there. And I write them myself, but it's no secret that a lot of opinion writing gets outsourced to law clerks, and these one-year wonders may be good, they may be bad, who knows. So if you run across opinions that don't seem to make sense, or you read unpublished opinions covering extraordinarily important areas like the McBroom case on the difference between trade secrets and confidential information, which is unpublished, and that's unimaginable to me because it's the most important opinion I've ever read on the subject. Don't get mad at us, we're trying to get there. And I think the advent of business courts has been a positive development. I also think, as several of you have pointed out, that the fact that the Michigan Supreme Court's taken a couple of areas in the oppression area, in the oppression context, is a good sign. But I'm going to end on a really hopeful note at the end of this, where I think this is going to be the solution to all the problems. Now, the other broad point I want to make is that for most judges coming at this problem, the general view going in, the operating philosophy, is that minority members or minority shareholders are just along for the ride, and that's what happens. I mean, what's the difference between a minority member of an LLC and me because I own 300 shares of Ford Motor? I mean, I don't get to tell Ford Motor Company what to do. I don't have any control over anything. Well, that's not really the right analogy. I mean, that's essentially like viewing the United States as a pure democracy. And as Franklin said, I mean, we're a constitutional republic. And that means that, sure, there are people assigned responsibilities in a representative capacity, but the Constitution walls off certain activities that are just flatly impermissible to protect the minority members of society. And minority opinions, whether they be thought or anything else. And the same holds true in the area of corporate governance. And that's why I think it's unfortunate if you're coming into court, particularly if you're not in a county that has a business docket or federal court where everybody's a generalist and that's just how it goes. And so you walk in with the judge not fully understanding that because of minority shareholder oppression statutes and other protections that we've talked about today, that there are certain inalienable rights that every member of an LLC or every shareholder of a corporation enjoys. And it's our job as the judge to protect them because they're certainly not going to be protected in the context of corporate governance. That's why they're in court in the first place. So let me talk about some specifics here. And a lot of this is just second nature for all of you. It's always tough to get up in front of people who know this stuff as well or better than I do. And several of you I know this stuff better than I do. And I'm learning that lots of the rest of you do. I may be the most ignorant person in this area of law in the room tonight. First of all, we know, and Michigan law has told us, that an operating agreement is a contract among the members of the limited liability company and the limited liability company itself. But, and so there are always claims available for breach of the operating agreement, just as you could have an action for breach of any other contract. But there are rights that exist outside the operating agreement, or rights that exist outside the corporate documents as well. And so it's important, I think, to help the judge understand that the contract isn't necessarily the end of the story. I mean, we like to glom on to simple concepts like the economic loss doctrine. So, you know, I see a contract action, I've got a bunch of torts behind it, I think, aha, they're all gone, economic loss doctrine. But the protections for minority shareholders are much better than just a common law tort claim. I mean, you're talking about a fundamental statutory right to assert a claim. And we've talked about the statutes today, but I think it's important to refocus a judge who's not getting it on the notion that you can have rights under the operating agreement or under the corporate documents and rights separate and apart from that. And the one thing that we judges in Michigan know is if you point to a statute, we think, all right, that's got to be an enforceable right. And so I would strongly encourage you, whenever you're representing somebody who has an oppression claim, that you almost immediately, at every oral argument, focus the judge on the statute. Because then I can look at it and I can see whether I'm looking at 450, 1489 or 450, 4515. I know, essentially, I've got guideposts to operate with. I mean, how many of you do receiverships? Anybody do some receivership work? All right. You remember the old statute. It basically says a judge can appoint a receiver for any reason or no reason at all, and it's totally in the judge's discretion, whatever you feel like. You can even do it on vacation. I love the fact that they have language in the statute that says you can appoint a receiver on vacation. I never do that, but that's what the statute
Well,
says.
you're on vacation while the receiver's on vacation.
And so there's just no control there at all, and so judges tend to be reluctant. And so what they do is they rely on the parties to draft the receiver appointment order, and that becomes the governing document, but who knows where that's going? That could be all over the place. So we worked hard in the last legislature to get the legislature to pass this thing called YUCRERA, the worst acronym of all time, the Uniform Commercial Real Estate Receivership. I'm not kidding, the acronym is YUCRERA. But it gives us clear guideposts that we can follow to figure out what the world we're supposed to do. And I would say the same about the oppression statutes, and I keep highlighting this, but I'm going to talk at the end about my great hope for salvation in all of this. Now, next. We talked a lot about the concept of unfair and oppressive conduct, and of course there's a long definition in each one of the statutes, but I simply would emphasize, because I was totally persuaded by this argument in case, and I think I got it right, I'll talk about it later, that you can also establish a violation that constitutes minority oppression if you can show illegal or fraudulent conduct. So that makes a huge difference, because obviously, when you're talking about willful and oppressive conduct, as long as the action's in conformity with the operating agreement or the governing corporate documents, it's got to be okay. You got to waive it on past, even if it offends you as a judge. But if it's illegal or fraudulent conduct, then it could be in complete conformity with the governing corporate documents and still be violative of the statute. And I found that in a case. If you want to go to my vanity press, you can find it, a case called Moyer versus Manis. I should have brought copies. After I dinked around for a paragraph, squeezing all the humor I could get out of the name of the LLC, which is Caveman Holdings. I can only imagine what I could all say about Caveman Holdings. I turned to the analysis and drew a sharp distinction between acts allegedly illegal or fraudulent on the one hand and acts allegedly unfair and oppressive. And I think that that distinction is lost on a lot of lawyers who do this kind of work. Not on those of you who are real sophisticates in the area, but a lot of people just don't get that. And they think, we're going to lose. All they did was exactly what they said they could do under the operating agreement. Well, that's not necessarily so. I'm glad somebody brought it up, because I scratched out a note to myself to mention it. And then, of course, you all covered it, so there's not much left to say, except for the fact that there's a certain futility about trying to bring a derivative action. And I don't know why people even think about it anymore now that we have the statutes on minority oppression. Because, as you know, it's hard to even get yourself in a position to proceed in the first instance. And then when you win, you're not just helping yourself, you're helping the person who's screwing you too. And it never made any sense to me, if you could proceed essentially directly on an oppression claim, why you would want to go the derivative. And so I see those very, very infrequently. And when they're pleaded, you can almost rest assured that nobody's met all the requirements to proceed on a derivative action anyway, and so it just gets dumped at the front end. 50-50 deadlines. somebody said it's like a really bad divorce, and I was in family court for 4 years when I first started. I mean, you got to be careful when you say anything's as bad as a really, really bad divorce, because I've seen some of those. But I think the analogy is fairly apt. If I were the king of the world, what I would do is I would never allow any business organization to be formed with 50-50 ownership. 2% would have to be assigned to the reasonable man, whoever that might be, and they get paid to essentially throw on their fire gear, slide down the fire pole, and then come running to put out the fire when all that brings loose. But of course, nobody ever does that. People form these 50-50 entities. And I just wanted to make the point that you will find instances, even in the 50-50 division, where you can proceed on an oppression theory because the other person is effectively in control. That Caveman Holdings case is a classic example. Now, they did it strategically for fraudulent reasons. They were essentially trying to protect one of the two brothers from being dispossessed of all the value of this gigantic promissory note that they had. So they put the other brother in charge of anything. Well then, brother dispossessed of all the rights files for bankruptcy, and the trustee takes over for him and says, "This is the most unbelievable operating agreement I've ever seen. He gets to do whatever he wants. He determines his own compensation. He determines unilaterally when there will be distributions as the managing member. He can't even be removed as the managing member unless there's a unanimous vote of the members. So he has to vote against himself to get himself out of the position." In that case, there's no doubt that the two members had equal interests of 50%, but I determined in that case, I think quite appropriately, that there was in fact oppression going on, and the person holding the 50%, but no control over anything, was being oppressed. Now, he wasn't going to assert any claim to that effect because it was great. He could sneak money out of there through his brother and never have to worry about his creditors. But once you get the bankruptcy trustee in place, you realize just how utterly abusive the situation is. And I don't offer that case for the facts, I offer it for the proposition that you can have 50-50 membership or 50-50 stock ownership and still have what I would view as actionable oppression. I want to mention one more point that somebody touched on earlier, but I want to emphasize it some more. We in the civil arena in Michigan are so hidebound to find things out through discovery that we often lose track of the fact that there are other ways to get information. And one of the best ways is the statutory disclosure requirement. I mean, I don't mean to call anybody out here, but Paul McCarthy uses this better than anybody else I've ever seen. And you get these great responses from people who are not particularly adept at dealing with the arguments. They'll come in and say, well, look, Your Honor, this is not within the scope of 2.302 as they define discovery in Michigan. And Paul will say, I'm not talking about any of that. We got a basic requirement under Michigan statutory law to make disclosures. I'm still a member, or I'm still a shareholder. Give me my documents. And there's no rejoinder to that. Even when the new court rules come into effect, hopefully, it was one of the architects of these, so I'm a big believer in them, that will reform discovery and allow us to impose proportionality requirements and all sorts of things to just end some of the excessive nonsense. There will still be all these statutory requirements to make disclosures, and you can always get your hands on documents that way. So please, don't forget about that. The final point I want to make, and I told you I was going to end on a really hopeful note, is that there is now something called the Working Group on Oppression Statutes. I suspect that several of you in the room are on that working group. If you're not, you need to know what they're doing. I got invited to participate in the first instance. I looked at the membership of the group and I just kind of stepped off to the side because I'm overcommitted as it is. And my first responsibility, because I get invited to be on all these things, is to make sure I participate if I think a train wreck is coming and try to prevent a train wreck. Well, I took one look at the membership of this working group and thought, nothing's going to go wrong here. And so I'm cautiously optimistic, and I'm kind of watching from the sidelines, but I'm expecting at the end of this process, we're going to have something that we can introduce that will really clearly define how exactly you proceed on shareholder oppression claims. And I'm promising you this, even though I've been on the sidelines, I'm happy to run the final leg in this one because I happen to be about to become, yet again, the once and future chair of the legislative committee of the Michigan Judges Association. So I essentially get to pick what we run, what we emphasize, where we use our lobbying power. Nothing would make me happier than to work with all of you, whoever's on the working group, to get something like that passed. Because just the same way, I think we've made a lot more sense out of receiverships, and we've made it easier for judges to get it right. I think we can do the same thing with the oppression statute. I mean, it's not, neither one of the statutes is a bad statute, but boy, we could do better if we worked at it. So I'm trying to keep an eye on it. Who's on that working group? Paul, are you the only one?
One of our old colleagues.
Okay.
Yeah.
Right, I know that they did a nice job of trying to get everybody on it, but please, I was one of the leaders of the group that rewrote the discovery rules. And what we did, the first thing we did was we started to reach out to other people. We realized there were only 13 of us, and we had holes in our knowledge base. So please, get yourself consulted on that. Keep abreast of what they're doing, because I have a feeling the final product is going to be something that we can all be proud of and work with. So I know it's just getting off the ground. I have no idea what the life cycle of this working group is.
Yeah, they're just starting with essentially a survey of issues to deal with, but it's going to be a pretty narrow focus because they want to accomplish something to get it through the legislature.
Okay, right. Well, please, don't take my lack of participation at the front end as any sort of measure of my level of interest. I'd rather be the one who tries to work hard to get it through the legislature once it's done, and I'll take almost anything that you produce, because given the personnel on the working group, I have no doubt it's going to be a great product. So, and I'll be glad to take questions. I didn't mean to go quickly and cut off questions, but if you have anything to ask me, I'll be glad to answer it.
Is the Caveman case called Moyer?
Yes, it's Jeff Moyer, who's one of the famous Chapter 7 trustees around. He's on everything. Moyer, M-O-Y-E-R, versus Manus, M-A-N-U-S, and Caveman Holdings. If you will indulge me for a moment, I'll read the opening paragraph, because if you're familiar with my opinions, you know what a lunatic
Let's hear it.
I am as a writer.
I think that would be a great thing to hear.
If you're not familiar with my opinions, I apologize in advance. I promise the levity is usually limited to the first paragraph. And if you don't laugh at this, I won't be offended. The name of the limited liability company here, defendant Caveman Holdings, LLC, conjures images of a few crude tools, some flint, a couple of rocks, and a collection of sturdy sticks. But Caveman Holdings is worth far more than that, because its sole asset, a promissory note in the amount of $1.85 million, serves as a veritable geyser of reliable income. That promissory note may not have been readily negotiable in the Stone Age, but today a collection of creditors wants to get their evolved hands with opposable thumbs on it. The two beneficiaries of that desirable promissory note, Richard Manus and his brother George, enjoyed the fruits of that note in their individual capacities until Richard Manus ran into serious trouble with his creditors. Before Richard Manus filed for bankruptcy protection, he and his brother formed Caveman Holdings. Then they transferred the promissory note to their new LLC. Because the court concludes, however, that Caveman Holdings cannot even serve as a loincloth for the Manus brothers' financial chicanery, the court must grant summary disposition to plaintiff Jeff A. Moyer in his capacity as bankruptcy trustee for Richard Manus, and contemplate the devolution of the property of Caveman.
Opposable thumbs.
If you've read my opinions, the first paragraph is off. And then after that, I swear, it's just straightforward analysis. Well, anyway, thanks for your patience. And honestly, call, email, carrier pigeon me any way you want. I try as hard as I can to be really accessible. And I know that the more communication there is between the bench and the bar, the better we're going to be. You're not going to get any better by talking to me, but I'm going to get a lot better if you talk to me. So please communicate with us. We're general jurisdiction judges, many of us who have, well, I have some commercial experience, but I'll end with the story of how I became the business court judge. If you want to know how incredibly precise the selection process is. We were told we had to run a pilot, and our chief came back to us at our conference on Mackinac Island, and he said, we got a problem. The state court wants us to, the state court administrative office wants us to run a pilot business court. And I don't know, anybody have any interest? Jim Redford looks at me and says, Yates has got an NDA, make him do it. That's how I got it.
Thank you very
Okay,
much,
thanks.
Doug. Very much appreciated. That was wonderful.